Good morning, Richard.
Good morning, Tim.
Thank you very much for hosting the Herefordshire Directors Forum the other evening.
Yes, an absolute pleasure.
It was a super evening, and we'll get on to the content in just a minute. But first of all, you've only been in this building for 18 months, and already you're bursting at the seams. How have you managed to make such a success in such a short period of time?
I think there's a combination of factors involved there. I think firstly, what we offer in Hereford is a unique offering. A firm of our substance, so we're in the top 100 UK law firms, and we offer a range of services to local businesses that really can't be paralleled. We've dedicated lawyers dealing with nothing but intellectual property. We have in-house patent attorneys. We have lawyers who specialise in banking, a whole range of corporate and commercial activity, and this is really not replicated anywhere else within quite a wide radius of Hereford, and at a very attractive cost base, because our overheads are a fraction of those firms, those big firms in the big cities, so our hourly rates are highly competitive.
That's interesting, and you also bring to the practice the fact you're a deputy district judge. How does that impact on your work in the practice?
First of all, the training is excellent. Another important aspect of that role for me is it's a quality mark, because it's an endorsement by the government that I have achieved a level of competence in my chosen field, which a lot of clients see as reassurance.
Indeed. And really our topic on that evening was all about shareholder agreements, partnership agreements, and my question really is, there were so many businesses, 25 directors of companies in the room, but hardly any seem to have one of these. Well, why do you think that is?
Particularly for family companies, it can be a thorny issue. They trust each other, and they therefore think any form of shareholder agreement is unnecessary. And I think there's also a degree to which they fear causing offence by suggesting that there should be one. But over the years, the roles within the business change, and someone feels that they're making a greater contribution than the others. They start to resent the fact that they're not receiving an enhanced share of the profits and the proceeds, because they feel that they're contributing more, they bring more to the party.
And is litigation always the answer, or is it possible to sort of mediate?
Mediation is something that is very much at the core of court rules, and all parties to litigation are required by the rules to attempt settlement by mediation, and there are cost penalties imposed on those who fail to do so. So just for financial reasons, it's massively important that people do attempt mediation. And mediation, in my experience, has quite a high success rate. I mean, last year I did 12, so an average of one a month, and 10 out of 12 achieved settlement, so that avoided a vast amount of cost in terms of trial.
And in terms of partnership or shareholder agreements, what's the essential difference between the two, please?
The essential differences would be with a company, you can limit your personal liability in a way that you cannot in a partnership. In a partnership, the individuals are what we call jointly and severally liable for the debts and liabilities of the partnership as a whole. So each of the individuals is going to share exposure to any claims, so you don't protect yourself in the same way. The advantages of partnership are to do with the privacy of your financial information. So whereas a company has to publish accounts, a partnership doesn't, so you don't expose yourself to visibility to the outside world of your financial affairs.
Well, finally, Richard, this topic is of huge interest to so many of the businesses that I actually work with. Could you tell me, what are the essential headings under either a partnership or a shareholder agreement? Is it all about profit and length of service, or what are the key elements, if you like?
The key elements are firstly about management. So in a shareholders agreement, you're defining the essential areas where you do not want to delegate that decision to others. You want to retain that within the group that owns the business. The other area with shareholders agreements also is transfer of shares. So someone wants to exit the business. What's going to happen to that shareholding? Do the remaining shareholders want to have a first option to acquire those shares? At what price? And so those are two of the very important areas to be covered in the shareholders agreement.
Great. Well, that's a really interesting overview, Richard, and very well done on all that you've achieved in the last 18 months. And
Thank
all
you.
the very best for the future. Thank you very much.